KGO-TV presents The Great Ideas, a program devoted to understanding the ideas by which we live. You are cordially invited to take part in this exciting adventure in uncovering the meaning of the ideas we all use every day of our lives. Each week at this time, Dr. Mortimer J. Adler, speaking informally to you across his desk, will undertake to explain one of the great ideas. And he will try to answer the questions raised in your mind by that idea or by his explanation of it. He invites you to send in your questions. A set of the first-year selections from the great books, donated by the Great Books Council of San Francisco, will be given to each person whose question is discussed on this program. KGO-TV brings philosophy to you in the person of Dr. Adler, one of America's foremost philosophers, director of the Institute for Philosophical Research in San Francisco, and editor-in-chief of the two-volume Syntopicon, or Encyclopedia of the Great Ideas. Today, he begins the discussion of law. Dr. Adler.
Good afternoon. Mr. Luckman and I welcome you to another discussion of the great ideas. Today, we begin the discussion of law. To prevent any misunderstanding, let me say at once that though a moment ago you may have thought that you heard me say law, I said law. The subject for discussion today is law, not law. I was born in Manhattan, which is unfortunately very close to Brooklyn. When I first came to the University of Chicago and started to teach the philosophy of law, I noticed a puzzled look on the faces of my students for the first few months. Many of them thought they were in the wrong class. They gradually understood that it was simply a mistake of pronunciation on my part, and that I really was teaching the philosophy of law. Let me begin this discussion of law by calling your attention quickly to some obvious facts about the meaning, significance of law in our thinking and in our actual life. In our thinking, the idea of law is closely connected with other basic notions, with those of justice and liberty and government and peace. For example, on the Supreme Court building, there is the statement that we all know so well, equal justice under law. With respect to liberty, we all know that the basic opposition is either freedom from law or the development of liberty under law. And as you may remember from our discussion of government, the three great functions of government are connected with law: the making of laws, the application of laws to particular cases, and the enforcement of laws. Perhaps the one connection that may not be immediately clear to you is the connection between law and peace. Let me make this connection clear by reading you two statements about law, one by the great Italian political philosopher Machiavelli, the other by the English political philosopher John Locke. Machiavelli says, "There are two ways of contesting, the one by law, the other by force. The first method is proper to men, the second to beasts." And a century or more later, John Locke, repeating the first phrase, said, "There are two sorts of contesting among men, the one managed by law, the other by force." And he comments on this by saying that when we manage our contests or differences by law, the thing we call peace reigns. But when we have to manage our differences or our contesting by force, then we have war. And he goes on to say, where the one, settling things by law, ends, the other, settling them by force, always begins. The reign of law is the reign of peace. The absence of law is war. Now, another way of catching quickly the importance of law in human life is to remember that one of the three great learned professions is the profession of law. That, with medicine and the ministry of God, represent the three most ancient and most important of the professions in which men engage. And there's a third way of remembering or holding before our mind the importance and the meaning of law in our lives. It is our general sense of what we mean whenever we think of anything as being lawful on the one hand, or lawless on the other. Let me show you this quickly. The opposition in our minds between the lawful and the lawless is an opposition between order on the one hand and chaos on the other. Whatever is lawful is in order. The lawless is the chaotic. It is an opposition between the right on the one hand and the wrong on the other. The lawful is the right. The lawless is the wrong. And in general, we have the deep sense that the lawful represents reason in our lives, the rule of reason, whereas the lawless represents the uncontrolled reign or rule of force. Now, if I turn from these lofty considerations to your own everyday sense or consciousness of the law, its impact on your life, as its impact on my life from day to day, I think I would say that the most prevalent sense we have of the law is the image of the law in the shape and color of a policeman. We often call a policeman walking down the street the law. We say, there goes the law. And along with that image of a policeman as the symbol of the law is the image, or the other images we have in our minds, of the consequences that follow upon our being on the wrong side of the law. Let me show you a series of pictures that will represent for us our ordinary understanding. Here is a picture of two women apprehended for jaywalking, a misdemeanor, an ordinary misdemeanor, let me hasten to say, of which any one of us, you or I, might be guilty any day of the week. And here is the picture of a woman apprehended from what would appear to be a much more serious offense. And then we turn to another picture, which is a picture of persons charged with crime, arraigned before a judge. And all of these pictures lead in our mind to the image which always hovers in the background, which is the image of the iron bars of a prison house, the ultimate sanction of the law. But it is unfortunate if we allow the criminal law to occupy the central place in our minds. We ought not to identify the law with the criminal law and with the apprehension, trial, and conviction and punishment of criminals. However important the criminal law is, it is only actually a small part of the law's contribution to our daily lives, the conduct of our businesses, the regulation of our domestic and corporate affairs, the protection of our property, our rights and liberties. There is one other picture which we ought to hold before our minds when we think of the law, a picture that symbolizes the civil law. It is the picture of a law library in a law office. And on the shelves are volumes containing the whole body of the law, both the state law and the federal law, both the statutory law and the common law, as that is manifested in the report of judicial decisions.
Dr. Adler.
Yes, Lloyd.
One of our correspondents, Mr. Charles J. Crotty of San Francisco, agrees with you about the importance of law in our everyday lives. He says, as you do, that the law seems to enter into every aspect of our lives. But he has a number of questions which he'd like you to answer. For instance, he asks first, what is law? Is everything that exists governed by law? Must every law be obeyed? And his final question, can some beings obey or disobey laws as they choose?
That's quite enough, Lloyd, to start us off. In fact, that very first question, Mr. Crotty, what is law, will hold us for a while. though in the course of answering it, I hope to be able to throw some light on the other questions which you have asked. I hope that as I go on now, all these three very basic questions that you have asked can be answered. But let me begin with the first question. What is law? I think there are three things in our basic understanding of law. The law that is represented in the pictures you saw a moment ago, the criminal law and the civil law. The three things are that the law is always a general statement, that it's a rule, and that it's the sort of rule which is an instrument for the government of a community of men. A particular decision is not a law because it is not general. A scientific generalization is not a law because it is not a rule of conduct. And rules are not laws if they are rules of art. For rules are laws in our sense only where they are instrumental in the governing of a community of men. Let me explain these 3 points a little more fully. Let's take generality first. For example, the statement, this matchbox is here and now falling to the desk is not a law. It's a statement about this particular event. A law must be a general statement. It must apply to all things of a certain kind and to every possible action of a certain sort. For example, in contrast with the statement I just made, the statement that all bodies within the Earth's atmosphere tend to fall to the Earth at all times and places. That is a law. It is the familiar law you know as the law of gravitation. But the law of gravitation, though it's called a law by scientists, is not a law in the sense in which we've been talking about it this afternoon. It is not a rule of law. To understand that, let's go back to the law library that you saw a moment ago once more. In all the thousands of laws contained in the books on those shelves, there is not a single law like the law of gravitation. They are all rules of conduct. Let me explain this distinction between a law like the law of gravitation, which is a scientific generalization, and the law that exists in those law books you just saw, which are rules of conduct. This chart, perhaps, will help us to get the distinction clear. The word law divides into two kinds of general statements: descriptive general statements and prescriptive general statements. Descriptive general statements, which are called laws, are scientific generalizations. They are statements which describe how things do in fact behave, and such statements cannot be disobeyed. They are the inviolable laws of nature. Here, as Immanuel Kant said, we have law in the sphere of physical nature, in the sphere of things bound by necessity. But if we turn to law in the other sense, law as prescriptive, we then come to something quite different from scientific statements. These are legal rules when they are prescriptive laws. They state not how things do behave, but how men should behave. And such rules can be disobeyed. They are violable, capable of being violated rules of conduct. And here we have law not in the sphere of necessity, but in the sphere of freedom, of human freedom. This is a fundamental distinction between laws in two basic senses, and we are concerned in this discussion with law as rules. You see, Mr. Crotty, that there's a sense in which law does govern all things, but the laws which govern all things are of two kinds. All things other than men are governed by the kind of laws which are the descriptive scientific generalizations the physicists and the chemists and others discover. Whereas men, in addition to being governed by those laws, are governed by the rules of law which are made in society. But are all the rules that guide men and direct men, are all these laws? The answer to that is no. There are many rules in human life which are not laws. For example, all the rules of art, the rules of cooking, the rules of driving a car, the many rules that govern the particular or direct the particular operations of our daily life. These are not laws. Why are they not laws? Because they are not rules involved in the government of a community of men. What we mean by a legal rule, as opposed to rules of art or other rules of operation, are rules that are instrumentalities in the government of a community. That explains, I think, why we use the phrase law and order. Because law is the principle of order in a society. And what do we mean by that? We mean it actually brings a community, a single unit out of a many. You all know the phrase. It's on all the coins we use, e pluribus unum, making a one out of a many. Well, a one cannot be made out of a many without law. For law is what regulates the conduct of individuals in such a way that they can live together and act together. It can produce, laws produce the concerted action of a multitude of men for a common good, rather than for their individual interests. So far, so good. We understand that laws are general rules governing communities of men. On this much, all students of law, all philosophers of law, tend to agree. But once we go beyond this point, we get into deep water. Once we go beyond this point, we meet one of the most fundamental differences in the philosophy of law, in human thinking about law. Let me present this fundamental difference, this fundamental conflict about law to you in the shape of two theories, two radically different and opposed theories of what the law is. I have in my hand here on these two cards the two most extremely opposed views of the nature of law. Let me begin with this one. This is the view of law taken by Thomas Aquinas in the 13th century. It was held by Aristotle in the 5th century BC. It was held in the 18th century by John Locke, the great English political philosopher, and by our own founding fathers. This view can be stated in the following way. Law is a rule made for the common good of a community, grounded in reason, instituted by the will of a duly constituted authority, and having coercive force. Let me comment on that statement. A law is not a law if it is not for the common good, but is only something to serve the interest of a private person. A law cannot be made by anyone, not even by someone with the power to enforce it. It must be made by a duly constituted authority, either by the whole people or by the representatives and with their consent. Without such authority, law is a law in name only, for otherwise it is merely an expression of force. But law, though it must not be merely an expression of force, cannot lack force either, because without coercive force, a rule of law would be merely advice or counsel. Because to be effective as law in the governing of a community of men, the law must bind bad men as well as good men. And the law binds good men through its authority and reason in conscience. But bad men it must bind by the application of its coercive force and by their fear of punishment. Remember that now. In the case of good men, the law has its binding power by binding them in conscience because of its authority and its being grounded in reason. In the case of bad men, they are bound only by fear of punishment. Now, in this hand, I have the opposite theory of law. It was first stated by a great Roman jurist, Ulpian, at the time when the Roman emperors were at their tyrannical worst. And according to Ulpian, the statement of the nature of law is as follows. Magnificent statement of the opposite view. That which pleases the prince has the force of law. You can substitute for prince, government, or party in power. That which pleases the prince has the force of law. It need not be for the common good. It can serve the interests of the most powerful man, of the prince, the dictator, or the party in power. It need not be grounded in reason. It can be a rule imposed by the will of the prince, or by anyone who has the power to enforce a rule. The prince need not have authority by consent, or as a representative of the people. He can have seized power, as a tyrant does. The law, then, is merely an expression of his power, an expression of force. And hence such laws, bind all men in one way and one way only, by their coercive force, by the fear of punishment they arouse. And so far as their attitude towards law is concerned, it obliterates the distinction between good men and bad. Now, this view of the law is not held only by Ulpian. It was held later by the celebrated English philosopher Thomas Hobbes, who was the great defender of absolute monarchy in England. And I must say also, it was held in our own time, by Oliver Wendell Holmes, Mr. Justice Holmes. Let me read you two statements that show this, one from Hobbes and the other from Holmes. Hobbes, for whom law is a command, and a command is an expression of will, not of reason, says, all laws, written and unwritten, have their authority and force from the will of the sovereign. No law can be unjust then, for the law is made by the sovereign power, and all that is done by such a power is warranted. Mr. Justice Holmes, in a famous speech that he made for the Harvard Law School, said, what constitutes the law? You will find some writers telling you that it is a system of reason, that it's a deduction from the principles of ethics, or whatnot. But if we take the view of our friend the bad man, we shall find that he does not care two straws for axioms or deductions. All he wants to know is what the courts are likely to do in fact. And then he goes on to say for himself, not merely for the bad man, the prophecies of what the courts will do in fact, and nothing more pretentious, are what I mean by the law. Now I'd like to summarize what we've just learned in these two basic views of law as they're opposed in this last chart. Let's go to the left hand first. And here we see the view of law that is taken by Aristotle, by Aquinas, by John Locke, by our founding fathers, and by many others throughout the whole history of human thinking about the nature of law and jurisprudence. On this side, law is regarded as something grounded in reason and instituted by will. Because it is grounded in reason and instituted by will, it is something which combines authority and coercive force. And because it combines authority and coercive force, it binds men, both in their consciences to obey it and through fear of punishment. It binds good men in their conscience and bad men through fear. Such law is certainly what we regard as a reasonable thing. It is law looked upon as reasonable law. Let's go to the opposite picture of law, the view taken in the ancient world by men like Ulpian, in our time, in the modern world, by the great English philosopher Thomas Hobbes, or by Mr. Justice Holmes. The law is something imposed by the will, not grounded in reason. Strictly imposed by the will. Since it is imposed by the will and the will alone, it is something which has force alone, and no authority except the authority of force itself. And it binds through fear alone, not in conscience. Such law is what we mean by arbitrary law. Let me emphasize this. When law has authority, it is reasonable law. When law is imposed by the will, it is arbitrary. The very meaning of imposed by the will is the meaning arbitrary law.
Your summary, Dr. Adler, recalls to mine, and I think leads quite directly to the question that I think you'll remember we received from Alan J. Flores.
Yes, I do remember the question. It's a very good question.
He's in Richmond, and he writes to you as follows. Well, he refers, first of all, to the age-old argument that law is made in the interest of the strong. And this was first stated, or at least was stated in very early times by Thrasymachus in Plato's Republic.
Right.
He goes on then to say, if this is so, that law is made in the interest of the strong, what validity would people of a democracy have in saying that their form of government is superior to any other form of government?
That's precisely the point, Mr. Flores, of the basic conflict about the nature of law between the two theories I just stated for you. The position of Thrasymachus in Plato's Republic, which is the same as, in essence, as the position of Ulpian, or of Thomas Hobbes, or of Mr. Justice Holmes, or of anyone that holds that law is an expression of might, not right. On that position, on that view, democratic laws, as you indicated in your question, are no better than tyrannical laws, or the laws of a tyrant. And democracy as a form of government is no better than tyranny. In fact, Mr. Flores, on that view, all government is tyrannical. But if we take the opposite view, which I describe as coming from Aristotle, Aquinas, John Locke, our founding fathers, and many others, law is then something not made in the interest of the stronger, but for the common good. And moreover, it must either be made, as John Locke said, with the consent of the governed, or as Aquinas said, by their representatives. On this view, democracy is much better than tyranny. On this view, I think I could show you why democracy is the best form of government, the supremely just form of government. Now, Lloyd, this basic issue about law, which we have been considering this afternoon, leads to a great many other basic issues, such as the issue about the justice of laws, or the distinction between good and bad laws. And it leads to such questions as the question, I think, raised at the beginning by Mr. Crotty, as to whether disobedience to law is ever justifiable, and under what circumstances is disobedience to law justified. Those who hold these opposite views about the nature of law tend to give opposite answers to these issues and questions. For example, according to the view that whatever pleases the prince has the force of law, there is no standard for measuring the justice of laws. As Thomas Hobbes, in the passage I read you, said, if law comes from the power, the sheer power of the prince, then you can't talk about an unjust law. Law is the standard of justice, and justice cannot measure good and distinguish between good and bad laws. Now, to deal with these issues, not only this issue this afternoon about the nature of law in which we find such radically opposed views, but these other issues about the justice or goodness and badness of laws, and the very difficult question whether disobedience to law is or is not ever justifiable, I think we must consider a number of things. We must consider the different kinds of law. Is the kind of law we've been talking about this afternoon the law of the state, the law of California, the law of the federal government? Is that the only kind of law that governs men, that is a rule of conduct, that is an instrumental in the governing of a community of men, or are there other kinds? In addition to considering the different kinds of law, we want to ask ourselves questions about how law is made. What is involved in the making of law? And then we ought to be able to go from that to the last, and what must be for us, for anybody, I suppose, the most ultimate of all questions, the question about the justice of law. By what standard are laws good or bad, just or unjust, expedient or inexpedient? Or can it ever be said, as some people seem to think, that one can't talk about the justice of laws? For law is the source of justice, and not justice the measure of the goodness and badness of law. Now, these are the issues we expect to discuss in the next few weeks. In fact, the order of our discussion will be next week, the kinds of law, and then a discussion of the making of law, and finally, in the fourth of our discussions, a consideration of the justice of law. These, it seems to me, are questions in which all of you must be deeply interested, and I hope you will send your questions in to us so that we can follow in the course of our discussions the points of interest and the kind of problems you would like to have us discuss, consider, even if we cannot solve, because these are, many of them, difficult and often insoluble questions. Thank you very much.